your M&A attorney has to have some understanding of tax law, has to have understanding of accounting. They need to understand what different options are available to both the buyer and the seller.
Welcome to a brand new episode of the M&A Mastermind podcast presented by Cornerstone International Alliance. I'm your host, Nick Olsen. On this show, I get the opportunity to talk with the brightest minds in lower middle market M&A. Together, we discuss industry intelligence, deal management, shared successes, specialized expertise, and much more. If you serve the small to medium-sized business owner, this show will offer you tactics and insights you can use and implement now to become a master in M&A. Hello, everybody. Welcome to a brand new episode of the M&A Mastermind podcast. I am here with the first ever M&A attorney in over 100 episodes, which is crazy to me. But he is a managing partner at DeWitt Law. For more than 30 years, has helped his clients navigate the complexities of M&A. He focuses on the lower middle market. He is a friend of Cornerstone. Please welcome my guest today, Terry Gerbers. Terry, welcome to the show. How's it going?
Very well. Thanks for having me, Nick.
Yeah, I appreciate you joining and taking the time. I know you're a busy man. But I think our topics are great today. I think, like I said, it's crazy to me that I've not had on an M&A attorney yet. So appreciate you being, my first call and you saying yes and willing to jump on. But to start the conversation, we're going to talk about, from your perspective, how the deal goes, talking about how to allocate risk and amongst the different, couple of topics, and just how do you choose the right M&A attorney, and why do you need an M&A attorney in a deal? But to start out, tell our listeners about your background and why did you get into M&A in the first place?
Well, I started out 32 years ago, more than 32 years ago, practicing law. I did a lot of business transactions and real estate transactions. For the last 25 plus years, I've been focused primarily on M&A. And I think the big reason that I did that is I realized that it was an opportunity for me to work with clients and businesses in a manner that was not adversarial. I mean, at the end of the day, if I'm doing my job right, I'm going to have clients on my side that are happy, and on the other side, they should be happy. It should be a win-win deal when you're doing M&A transactions. So I've been blessed with the opportunity to work in an area of our profession that's non-adversarial and gives me a lot of peace at the end of the day. And I'm happy to see people be successful in both entering into a business and exiting their business.
Yeah, that's a good point because, as a sell-side M&A firm, you want the best deal for your client. But part of the best deal is also a happy buyer because, you will have an overlap of working together. So it's very interesting that you mentioned both sides of the table there. Tell us our listeners about the experience. Obviously, you have over 30 years of experience, but you got a team around you and your firm. What does the experience look like if anybody's looking for a quality M&A attorney and firm? Like, tell us a little bit about your firm.
Sure. I would say that, DeWitt, first of all, has offices in Minneapolis, Madison, Brookfield, and Green Bay. As far as here in our Green Bay office, I had, like I said, 25 years of experience in M&A transactions, probably did 250, 300 transactions ranging in value from about $1 million all the way up to $75 million. So it's a big range of lower to mid-market transactions. And I think what sets maybe our office apart and our staff apart a little bit, we have three of us that do this. Nick Burkett in our office has been doing it directly underneath me for 8 years. Katie Bloom, who is with us, she had joined us a while back. She has over 20 years of experience. Every one of our M&A attorneys has a business undergraduate degree, so they come in with a fair amount of business knowledge, makes the transition into M&A a little bit easier. And I think that expertise is helpful to our clients.
Mm-hmm. Awesome. Well, appreciate you sharing that information. And so let's dive into the topic here. But first and foremost, in an M&A transaction, why, a client might have their attorney, they might have worked with for a long time, but maybe they're not an M&A attorney. So why is it important when you're looking to exit your company to have a dedicated M&A attorney rather than just a general business attorney?
That is an excellent question, Nick. It that as business attorneys, which I did, for the first several years of my practice, and still do a little bit today. You're taught to fight for your client on every issue that comes before them. So if you're negotiating a contract, every part of that transaction should be favorable to your client, right? That's the way we were brought up. That's the way we were trained in law school. That's what we learned in the courtroom when there's ever a dispute. And what makes M&A different is that, like many of the other advisors, you have to be a facilitator. And there's give and take in M&A transactions. It's much different than practicing as a business attorney. And I'll point out that is a very touchy subject. If you have a client, a seller, who's worked with an attorney for 20, 25 years, they're going to be very loyal to them. And quite frankly, in most cases, that attorney is very concerned, wants to make sure that the client gets a good result. So what we
Mm-hmm.
try to do in our practice is, if that relationship exists, we don't kick the seller's business attorney to the side. We will work with them to do the transaction, but we'll still rely upon them for providing information in due diligence, for providing the resolutions, for assisting us, so they don't feel as though that they're being kicked to the side by the seller. But it is important to draw that distinction between an M&A attorney and a general business attorney.
Mm-hmm. So, in what ways does having the right legal expertise shift or reduce the risks for both buyers and sellers in a deal, to make sure that you do have the legal expertise, but the right expertise?
Well, again, I think the point is that when you have the role of an M&A attorney, you become more of a facilitator, more of a strict business attorney becomes it can be a deal breaker. And we've run into those situations. So what we're trying to do is, you want to find someone who has the expertise in handling these types of transactions, number one. Number two, understands the lingo. Number three, understands the business aspects of it. Number four, understands the tax impact of it. So there's a number of different things that you're juggling, that we're not going to rely just upon us. You're going to have a CPA involved as well, but your M&A attorney has to have some understanding of tax law, has to have a center of accounting, whether we're dealing with working capital, whether we're dealing with allocation of purchase price, whether we're dealing with the structure of the transaction, if we're doing a stock versus an asset deal, if we're doing an F reorganization, or if we're doing an S corp that's going to be taxed as an asset sale, like what's called a 338H10. They should know the lingo. They need to know. They need to understand what different options are available to both the buyer and the seller.
Mm-hmm. And when you work with an M&A advisor, how closely do you guys work together during the process? You talk about lingo to understand the process. Obviously, you got your expertise, but what what does it make? Does it make your life a lot easier when you have an experienced M&A advisor who knows knows a little bit about it, but also kind of leverages you as your expertise? Kind of that dynamic between you and the advisor is important, right?
Absolutely. That's number one. I mean, quite frankly, if somebody came to me that was a M&A advisor and said, "Listen, I'm somebody looking to sell their business. I'm going to help them do it. I'm going to prepare the LOI myself, the letter of intent myself." I usually say, hold the train. If you're going to be looking for our assistance on it, we're going to need to take the lead. Conversely, when I work with an experienced M&A advisor, it's very easy. They understand what we're trying to accomplish. Similar to us, they're wearing the hat of a facilitator. They're trying to make a deal come together that's a win-win for the buyer and the seller. And quite frankly, their assistance, especially in the due diligence phase, as well as like scheduling to the asset purchase agreement, that is invaluable. In fact, it saves the client, at least on the sell side, a heck of a lot of money, because they're doing that as part of their service to the seller. And if we have to do that, we're charging for that. And quite frankly, having that option to have them assist with some of that and even keeping the deal on track is very important, to have a qualified M&A advisor.
Mm-hmm. Uh, yeah, I think that's good insight. Um, as an M&A advisor, if you're looking for, maybe you don't have a relationship with an M&A attorney, but you're looking for an M&A attorney to recommend for your client in a transaction, what are some things our audience should know when choosing that right M&A attorney?
From an M advisor, whether it's an M&A advisor or whether it's a seller, I would look at the experience that they've had in the M&A realm. If you're talking to an attorney who says, "Yeah, I can do that," or Joe in the office or Ellen in the office can do that, they've handled a couple of these things before. This is probably, in most cases, the biggest asset that a seller is going to sell or a buyer is going to acquire. The last thing you want to do is have that not be done in the most efficient, most accurate manner. And quite frankly, asking, one, their experience, two, throw out some lingo. Throw out, hey, what is working capital? I've heard some people talk about working capital. If they tell you they got to get back to you on that, or they don't understand how it works, you're probably not with the right person. Or if you just say, listen, what type of reps and warranties am I going to be expected to make to a buyer on a sell side? If they can't answer that question, or we'll have to see, you know, then you're probably not with the right party. And it's amazing because a lot of our transactions now, everything's become so interstate commerce related. We'll do a transaction, even in our case, sometimes out of state. So we're not necessarily operating in Wisconsin. I would say that, you know, over half of our transactions are still in Wisconsin. But when you're dealing with the other states, it's interesting because what will end up happening is we've done transactions where neither attorney has been from the state in which the transaction is occurring. Because what will end up happening is we'll end up going to like a common law that's well known, Delaware law. So we did a transaction in North Dakota one time, a significantly sized transaction, and we were here representing the seller. The buyer was represented by an attorney out of Los Angeles. So when we run into that situation, we'll apply Delaware law because everybody understands it. Everybody knows that it's common application, and most states now permit us to operate in their state as long as we have a certain number of years of experience and we're dealing with the Uniform Corporations Act. So it's pretty clean and easy to do interstate commerce today and transactions, which makes it easier to find a qualified M&A attorney.
Let's dive into the kind of the deal now. And you had just mentioned working capital. And I've heard you mention working capital a lot, so I know it's important to you. Why is it an important component from a legal and risk allocation perspective that business owners not underestimate the role of working capital in a transaction?
Well, working capital is close to my heart. I think I've shared that with you before, Nick.
Yeah.
It is something that has to be looked at by a seller well in advance of closing, well in advance of taking it to market. And it's something that's very underestimated because why? At the end of the day, if you're a successful business, what are you doing? You are slow on collecting your accounts receivable. You pay all your bills when they come in. You overload on inventory when there's a sale. All these things can harm you when you go to bring your business to market. Because it used to be that every buyer would just go get a line of credit, and the seller would keep all of their working capital. And for your audience that doesn't understand what working capital is, it's your current assets, which are generally your accounts receivable, your prepaid expenses, your inventory. It usually excludes your cash and your current liabilities, which are your accounts payable and your accrued expenses, whether they're wages, taxes, etc. So what we're doing is we're trying to figure out what that working capital is because now the buyers no longer rely upon working capital. They expect the seller, as part of the purchase price, to include with the sale working capital, which is the gas in the tank to keep the business going. It is typically 1 month's worth of net working capital assets, your current assets less your current liabilities. And it's factored on usually a 6 to 12 month period, but that can fluctuate. So when we're telling people before you want to take your business to market, both the M&A advisor and the seller, you should be focused on your working capital. You don't want to starve your company, but you don't want to be overloading on inventory, or you don't want to have a large accounts receivable out there that you're not collecting. Because guess what? When you go to sell that business, they're going to be expecting that to be paid to the buyer.
Mm-hmm.
It's cash out of pocket. Every dollar of working capital that you have on the books is cash that you're leaving on the table.
Wow. Very interesting. I love that explanation. I think that's very informative. When you're looking at a deal, what kind of disputes typically arise around working capital calculations, and how do you structure deals to kind of minimize those conflicts and maybe some of the things you just mentioned?
Yeah, some of it is what I mentioned. One of the big ones is seasonality of businesses. So if we're looking at a trailing 12, that's generally going to capture the entire seasonality of it. Now, if you have something where you have more sales of either a product or services in summer months, for instance, we just did a transaction. We closed on it about a week and a half ago. A large waste company that they haul ash to different places. Well, they don't do that primarily in the wintertime. So what they're doing is they're doing that more in the season where they can haul it and it's brought in. The problem that you run into is if somebody is saying, well, we just want to look at the last 6 months, and those 6 months are detrimental to the seller, we'll want to say, well, wait, that doesn't really seem fair because we get it that we're in that seasonal period of time, but it's really fair. You're buying the business on a 12-month schedule. So why aren't you looking at the full 12 months? So we had to negotiate a deal in that arrangement. So seasonality is a big one. I would say the other one is if you have a large accounts receivable on the books that you've been holding that you know you're going to get paid for, but it's been on the books for the better part of a year, and the seller says, "Listen, I really don't want to give an extra 100,000. Say the receivable is 100,000. We don't want to give the buyer an extra $100,000. That's our money. It's been hanging on the books for a year. It really has no bearing on the month to month." And I would probably say the biggest one is excess inventory. In fact, we've had examples of excess inventory that are pretty traumatic.
Do you have one maybe an example of that excess inventory that you can share?
Yeah, we can. We had a company that did it was in 3 different states. They were a large distributor of commercial and agricultural tires for vehicles, tractors, semi trucks, and trailers. Well, during COVID, they had told their manufacturers, fearful of a supply chain issue, they told all their manufacturers, we'll buy whatever you can produce. And what they did is they ended up accruing, I can't remember the exact number, but it was sizable, about a $6 million excess inventory amount.
Mm.
When we took that business to market, or when the M&A advisor took that business to market, that became a big stumbling block because the buyers come in and are saying, listen, your inventory for the last 12 months has been consistently in that $5 to $6 million range. We want $5 to $6 million of inventory included in the transaction. And the seller is just like, well, that's about 50% or 60% more than what we would ordinarily have on hand. We only want to give you what we'd ordinarily give you. We got close with one. We were willing to they're willing to take $6 million and reduce it down to two, but our client wasn't willing to do $2 million of excess to transfer $2 million of excess inventory. So what we ended up doing is the seller ended up pulling it off the market till they absorb some of that inventory and then taking it back. And that's what you can run into. It's a very common situation where working capital was not properly managed. Now, had they anticipated they were going to go to sale, you would not have made that arrangement. Again,
Right.
you don't want to starve the company. And I get it that they did it in a time period where supply chain issues were a concern, but that was a lot of extra inventory to be having on hand.
Mm-hmm. Yeah. Yeah, and it's something you think like you're doing right because you're getting a good deal on it, but being mindful of the fact that you don't know when you're going to sell, but you still want to be mindful of that, regardless if it's 1 year, 5 years out, 10 years out.
That's a great point. I mean, at the end of the day, working capital should be managed all the time. I'm just telling you that my experience has shown that when sellers are ready to go to market, assuming it's not a fire sale, they get lax. They get lax on collecting those accounts receivable. Imagine if you ordinarily have $1 million of accounts receivable, but because you've been letting people slide, you have for the last 12 months, you have $1.5 million of accounts receivable that are hanging out there. That $1.5 million, the buyer is going to expect at the time of closing. As a result, the seller just left $500,000 of cash on
Mm-hmm.
the table that they gave to the seller that had they been managing their working capital, they would have put in their own pocket.
Yeah, that's great. That's great advice, and definitely something that you can put into practice with your clients immediately, and just at least checking that out if you're not already. Another allocation of risk in an M&A deal that we wanted to hit on today was intellectual property. Easy for me to say. It's very important in a transaction. How often do you see situations where business owners don't own all of their IP or don't know who owns it, and what risk that does that create in a transaction?
It's going to really affect value, number one. Number two, it's going to affect the ability to make claims post closing. I tell clients all the time, generally as it relates to reps and warranties, really what you're trying to do there is to answer the items that you know you control. You want to make sure that that is what you're making reps and warranties as of. And some of these things do boil down to an allocation of risk. Sometimes a buyer is going to say, listen, I'm buying your patents. I'm buying your copyrights. I'm buying your trade name. I am buying your website. Those types of things, they're saying it's not fair for the buyer to assume the risk that that's not good. It's not qualified. So when it comes to intellectual property, when it's an allocation of risk, that's one of the stickier points in a transaction because the seller is saying, listen, as any attorney will tell you, a patent, a trademark, a copyright, it is only as good as its first lawsuit. You may have a patent out there, but until it's challenged in court, you don't know how strong that patent is. So every time we're representing a seller, we're trying to say that to our knowledge, we have the rights to our trademarks, our patents, our copyrights, but we can't guarantee it. Um, and it's an interesting concept because you just assume you do, but do you really know whether or not someone, say we're doing a deal here in Wisconsin, do we really know if someone out in New York isn't using the same name we are for the same sale of products? We don't know that. So to say someone isn't infringing upon our mark, we don't know that for sure. But again, it's an allocation of risk, what we do to minimize that on a seller side of the transaction is we have very good intellectual property attorneys in both our Brookfield and Minneapolis office, quite a few of them. They represent colleges and so forth with their research and their patents. So what we'll do is we'll ask them to do just a general U.S. PTO search, U.S. Patent and Trademark Office search on the name to make sure that no one else has a patent on that, or excuse me, a trademark on that name. And that at least minimizes the risk so that you have that. And that's very helpful in at least trying to minimize that risk. Because if I'm the buyer, if I'm representing a buyer in a transaction, I'm like, why would you want to assume that risk? Aren't you paying extra for that patent? Aren't you paying extra for that trade name, that copyright? You're paying for that website, which is a really good example. That one happens all the time. Websites.
Where that what they don't own the domain, they don't.
Yeah, we had a transaction. They own their domain. They have that registered. What ends up happening is that most most of our clients will use a third party source to develop their website.
Mhm.
You don't think about it when you're signing the contract with a website developer as to who owns rights to your website. You're just assuming I paid for it, so therefore it's mine. And that's almost never the case. Almost never. And we had a transaction. It was about 5, 6 years ago now. A really nice. The guy developed. He wanted to develop a compressor system in his own garage. So he developed a a gas and air piping system for his garage, and he was so impressed by what he did. He's like, I can market this to third parties. So he wanted when he took his business to market. We were not representing him as a business. His M&A advisor sent him over to us, and I looked at his numbers and I compared him to other industries. I'm like, you are doing so much better, like 3 times what your competition is in sales, gross margin, and EBITDA. So what makes you so special? What are you doing different than your competitors? He explained to me that you can go onto his website and you can actually do all the dimensions of your space, but you just measure it by right down to the as small of an inch as you want to get, a quarter inch, eighth of an inch, whatever it is. You tell them what direction you're going from there, 45, 90, whatever the case may be. And what we do is you could design it on the website. You punch it all in. It would give you a quote. If you liked it, you accepted it. It would literally ship the product right to your door. There was no hands-on communication with our clients. So it was a great system. And when I met with him, I said, "Who owns the rights to that website?" He's like, "Well, I did. I paid for it." And I said, "Are you sure?" I said, "You better go take a look at your contract." So he drove home that night. He called me. He called me at night that night. He called me on my cell phone. He's like, he says, "You were right." He says, "I don't own it." So we ended up having to go to the website developer to make sure that we actually had to acquire not just the website, but the underlying codes for that website that were going to protect him, that and we had the website designers say that those codes would never be released for anyone else in the air, gas, and at that point we added water piping industry so we could take the product to market. That deal closed, if I recall correctly, for $48 million. I can tell you for a fact that had he not done that, he would have been lucky to get 15. And
Wow.
he had to pay $150,000 to get that back. And my client was wild about it at the time, but when we got done with the transaction, our client was very appreciative of what I directed him to do, and he realized that at the end of the day, that was what he had to do for the best return on his investment.
150,000 for what is that? 36
Probably a
million
thirty
more.
million dollar difference in purchase price.
I
Yeah,
think that's money well spent.
it was. It was very very well spent.
Yeah. What advice would you give business owners to get ahead of this to make sure it doesn't become an issue when they are ready to sell?
Well, one, look at your contracts. Look at what you do own. I would say start with the website because that's obvious. Make sure of that. You can work with us to do a United States Patent and Trademark Office search. Make sure no one else is using your name. It's not a bad idea, especially if you are engaged in interstate commerce and have the availability to file a federal patent to go ahead and do so. I will tell you that state patents aren't worth the paper they're written on. They may protect you at that state level, but and I won't get into it for purposes of our conversation. You do have common law rights depending upon when you start using a name versus when someone files for protection. So you still have what's called a regional protection where you've done business, they can't take it away from you. But I would do that. I would probably encourage. I know that I talked to just recently one of our Brookfield attorneys. We had them review. We had a very good patent that was going to be included. It compromised a good portion of the purchase price. So we actually did a patent search to make sure that one, the patent was valid, and we believe that there wasn't other work out there, other patents or patents that were in process that would interfere with what we were trying to sell, knowing that the buyer was going to insist upon us guaranteeing the validity of that patent. These are things I can tell you right now that someone who's not experienced in this industry is not going to recommend that you do. They're not
Yeah.
going to think anything of it. They're going to think you have a patent, you're protected.
Mm-hmm.
When you've been down this path a few times, you want to make sure that you dot your I's and cross your T's as best you can.
Mm-hmm. Yeah, and having someone like yourself who's been through it for, we said 200, 300 transactions, like that's someone you want in your corner who's been through it and knows what to look for. So it kind of leads into my last question, Terry. We talked a lot about allocation of risk. What are the most impactful ways in which an M&A attorney helps balance and allocate that risk so both parties can feel good about a deal and to make sure that everybody's taken care of?
Well, the best thing to do is again understand the significant process. But at the end of the day, what we want to make sure is that we're not taking a risk that is unreasonable. In other words, is there a 10% chance that a warranty claim may crawl out of the woodwork? Yeah, that could happen. If you're a seller of products, you may have a warranty claim that crawls out of the woodwork. Usually, what we want to do in that case is we're going to limit the time period in which claims can be made against the seller if we're representing the seller. So we will say, we'll try to get away with 12 months. The buyer will ask for 24. We'll probably meet in the middle at 18 and say, all right, for 18 months, we'll do that. We will make sure that if we're going to give that in the intellectual property assurances, that we've done everything we can to make sure that there's not a claim. Employee disputes are another big one. Environmental issues can be a big one. We want to limit those claims on behalf of the seller. And I'm sure you've other guests talk about it, but we talk about caps and baskets where, there's no claims unless we hit a certain dollar amount. We want to limit the total amount of any claim unless it was fraudulent. Those are the types of things that we'll want to do. At the end of the day, I tell all my clients when we're taking them on, my number one job as your advisor from an M&A attorney perspective is to make sure I don't let you step on a landmine.
Yeah.
I can tell you, out of 250 to 300 transactions, the post closing seller claims I've been involved with are less than the fingers on my hands. So it's very limited that we've ever had issues because we manage that risk in a manner that protects the seller. And similarly on the buyer side, we want to make sure that the buyer has done all of its due diligence. That's the benefit of having a firm of 100 and I don't know, we have now 130, 140 attorneys firm wide that we're able to rely upon resources. If we need to do some environmental work, we need to do some employee stuff, we need to do some intellectual property. If we have a business that's focused on that, we will outsource that to some of the attorneys outside the Green Bay office to make sure that we're protecting the buyer's interest. Because on the buy side, you have a lot more due diligence involved with the transaction because we'll work with CPAs to get a quality of earnings report. We rely heavily upon M&A advisors qualified like Cornerstone to make sure that they're doing a little bit of investigation. If they dig something up, they share it. The beauty is that if there is something bad in your past, we want to face it head on because everybody's going to find any buyer coming in is already excited about your business. So that's the time to disclose everything that's ugly about it. If there's a problem with it, we want to disclose it. We want to deal with it. The only time we've ever run into situations, I remember one where a client didn't disclose something that was not readily available. In that case, we were able to swiftly resolve it. And it wasn't even a big deal. Had he or she disclosed it at the time when we did the transaction, it probably wouldn't have even been an issue. But other than that, usually what ends up happening is it's something that the buyer has had a problem with that wasn't expected, and they may make some claims. I can tell you in that the ones that we can count, the less than 10 transactions that we've had post seller claims, I bet more than half of those, there was never a liability on behalf of the seller. It was just something where, they said, oh, geez, an employee came up and said that they knew about something that you didn't disclose. Well, who is that employee loyal to now? They're not loyal to the seller anymore. They're loyal to the buyer. And that's another good example. We always try to limit the knowledge qualifiers. Who is bound to that? A good buyer's attorney is going to say, listen, we want knowledge of not just the owners of the business, but we want knowledge of all of your key managers in the business. I will do my best to make sure that doesn't happen. I'll say, listen, we don't have control over them. All we have control over is the owners of the business. We're not even disclosing this to many of our managers. So the only thing we're going to warrant or represent is the knowledge of the owners of the business, not any key employees. Yeah. So at the end of the day, a roundabout way of answering your question is just make sure that person has done more than one or two M&A transactions because they will know how to allocate the risk for you. It's important that be done. And if it's done correctly, even if there's some risk that the seller assumes, the chances of ever having a problem or liability result from that are very minimal. And quite frankly, the seller is going to be happy. We had a transaction years ago that your firm brought us into, and it was a deal in Michigan. It was a $26 million deal, and they had their business attorney write the offer because he said he was qualified to do it. He gave this thing a bloodbath. He took the asset purchase agreement and marked it all up and objected to every rep and warranty in the transaction. Almost every one of them was redlined to the point that the buyer's counsel reached out and said, listen, we're canceling the deal. We're not going to go forward. Your office brought us in, and we ended up looking at it. And at the end of the day, there were about 4 issues that remained. And we were able to negotiate them in about 10 days, got the deal back on track. It closed. And the seller was so satisfied that we've done other work for the seller since. So it was something that, it just about destroyed the transaction. And you're going to have that allocation of risk. You're not going to win every battle. What you want to do is win the battles where there's any risk. And sometimes, a little bit of risk is better than a lot of risk. We're not going to let you take a lot of risk.
Yeah. Terry, amazing information, great insights. And I've learned a lot from our conversation here today. I know our listeners will as well, or have as well. But where can everybody find more about you and your firm and the great work that you guys do?
Well, I would recommend you go right to our website, www.dewitt, DEWITT, LLP as in partnership.com. You'll find information not just about me, but our areas of practice, our wonderful attorneys here in the Green Bay area, as well as other offices, including those intellectual property attorneys I shared a little information about with you. So that's great, great organization. I'm happy with all the support we get from the firm, and always happy and willing to assist M&A advisors, sellers, buyers. This is what we do for a living. I enjoy it. I'll probably do it as long as I possibly can because I like putting deals together and having people be excited about not just selling a business but acquiring a business. Again, it's a win-win transaction. I feel blessed to be in the area of practice that I am.
You can tell you're passionate about it, and obviously you're very good at it. So I think you picked the right profession, Terry. Thank you for joining the show. That's all we have for this episode of the M&A Mastermind podcast. Do Terry and myself a favor, like, share, comment, pass this episode on to anybody you think might benefit from our conversation. Subscribe to our YouTube channel at Cornerstone International Alliance. Check out all of our episodes at cornerstoneia.com/podcast. Tune in every Thursday morning when a new episode airs. Until next time, everybody, take care. Thank you for joining us on this episode of the M&A Mastermind podcast, and a special thank you to our presenting sponsor, Cornerstone International Alliance. If you enjoyed today's discussion, don't forget to like, share, and comment. We'd love to hear your thoughts. Make sure you hit that subscribe button so you never miss an episode. We'll be back next week with more insights, strategies, and real-life experiences to help you take your M&A game to the next level.